1 second, hold on. I'm trying to find it. One second. Hold on. I found what I was looking for, though. Real quick. Key differences. True and correct copy. Self-declared. Self-declared or informal verification. So if someone self-declares that the document is true and correct, what happens if they don't have personal knowledge? And yes, ma'am, motion to authenticate. Let's say if I work for a company for a year and you executed a contract with the company 3 years before I worked there, and I say that the document is original, I don't have personal knowledge of that because I wasn't there. I've only been working with the company for a year, but this contract was executed 2 years before I got with the organization. So how can I prove that that's a true and correct copy? This is what people aren't telling y'all. I know it because I've been listening to some of these lies that people share me. Ain't no one bringing this up. And I'm trying to figure out why. Because this is a landslide right here. Don't y'all think so? Certified copy. Officially certified by a notary or authority. Highly recognized in courts and official processes. Legal filings, formal applications, or other records may involve a fee for certification. But the certified copy has more weight because it basically acts as the original. So when we look at these promissory notes that they try to assert into the record, we know good as day that they don't have them. They don't got the documentation, not on hand. Not on hand. Y'all want to see something else that's funny? So I want to show y'all what they do to you guys, what they do to us. We have Jolene Moon. Jolene Moon is a litigation support coordinator for Discover Bank. Look at her affidavit. Look at her statement. They use literally copy and paste letters and dunning letters for us all the time. So I'm gonna show you guys the comparison. So let me know when you read it. Jolene Moon personally appeared before me on this day and after being duly sworn according to law and upon my oath and states and follows. I am a litigation support coordinator for Discover Bank. I'm going to show you how bad they copy and paste just because they know that we're not going to go into court. They got it down so good that they know that we're not going to go into court. Is that the double one? Where's the other one at? 1 second, y'all. I got to get these pictures together. So we have Jolene Moon, and then we're going to pull up Roderick. 1 second, if I could find him. Let me see. Where is this thing at? Don't these look exactly the same? $6,701.51. Roderick Boyer personally appeared before me on this day after being duly sworn according to law. They just copy and paste. So y'all can't sit here and tell me these individuals don't think that they all automatically assume that we don't know what we're doing. We don't look at our paperwork. We don't know what we're talking about because we don't look at the paperwork. We're not reading the documentation. These things are literally just copy and paste. So we have Roderick Boyer. I am a litigation support coordinator for Discover Bank. Literally verbatim. And I'm going to pull back up the other one. Roderick Boyer. And then I'm going to pull up Jolene Moon. So y'all can't tell me that that's not funny. They copy and paste this stuff because they know that we don't know no better. So my job is to make sure that we do better. So I hope this live benefited some of y'all. These are different strategies that I use on a day-to-day basis. Literally every day. I think about the big picture every day. I have to. So as I go through consultations, if I see things that I think will benefit the crowd, I'm going to redact your information and we're going to go through it just like this. If you're wondering what a consultation looks like with me, it's basically this format, but on Zoom, and it's just me and you. That's it. Me and you on a Zoom, we're going through your documentation. You're asking me whatever questions you want to ask me, and I'm providing you with direct feedback. I don't think that's a good idea. This document should have been done better. You might want to revamp that. We got to focus on this. That's the direction you guys want, because everybody wants results. The result you're looking for from me is understanding. So if you're looking for understanding, what are we waiting for? Why haven't you done a consultation yet? If you're looking for understanding, why haven't we done a one-on-one yet? And that's the thing, I'm doing it free on live right now. And since I'm in a good mood, is there anybody that would like to, because what I'm going to do, because somebody reached out to me before for one of my classes, because I was doing a special. So I was doing a pre-enrollment fee. But if there's anybody that would like to get into my classes for this week, I will drop the price down from $750 to $500. So regardless of the repossession class or the foreclosure class, if you want to get inside those classes, I will drop the price down now to $500. So for foreclosures, I will drop this price down to $500 today. What comes with this class is, for everybody that signs up, depending on the area that you're in, I'm going to be providing strategies for your jurisdiction. So if you're in Texas, I'm going to provide you with Texas procedures when we do our class. If you're in Tennessee, I'm going to provide you with Tennessee. If you're in Florida, yes, ma'am. Matter of fact, if you're dealing with credit cards, I would just recommend a consultation. 100%. And I'll even cover credit cards right now. If there's anybody right now dealing with credit card debt, I can help you with credit card debt too as well. So I'm going to go back through my favorite one, Discover Bank. So with credit cards, so with anything regarding contracts, I have to see the paperwork. So I'm going to request you to provide me with the retail installment contract, any notices that they provided you, and any notices that you may have sent them, so that I can be caught up on what's going on right now. So Discover Bank, I'm going to go through a couple with you today. Matter of fact, if anybody is going through credit card debt right now, so we have Comes Now, Plaintiff, Discover Bank, buy-in through undersigned counsel, and for this cause of action against the defendant, states and alleges the following. At defendant's request, plaintiff issued a credit card to the defendant for which defendant agreed to pay plaintiff for all purchases made. So as we're looking at the top, we're understanding that, hey, they're referring to a contractual obligation. So basically, Discover Bank is saying that we breached the terms and conditions of the agreement by not making or keeping up with our payments. Long story short, pursuant to the credit card agreement, we're seeing it again, agreement, which means that they have to have a contract into the record. Plaintiff paid various merchants and banks for defendant's purchases in cash advance for which defendant was obligated to repay. After giving defendant credit for all payments and set-offs, there remains due and owing $8,292.98. All right. So in this scenario, we focus on the petition. So when you send me your document and email and I look at your petition, I'm looking for the exhibits. What do they have filed? Do they have any supporting facts to prove that you owe this debt? And if not, we're going to exploit that. So in this situation, remember, the attorney, so it says, comes now plaintiff, Discover Bank, by and through undersigned counsel. So we know that the attorney is the one asserting this information on behalf of Discover Bank. We know that the attorney doesn't have any personal knowledge. And let's say the attorney reached out to Discover Bank for the original agreement, original contract. And Discover Bank says, we don't have it. So the attorney has to pivot for Discover Bank. You don't have the contract. I'm taking him to court for breach of contract. I have to be able to establish that there's a contractual obligation between HunnitK and you for us to win. So what the attorney is going to do is he wants to get me to testify against myself on the record. That's why anything you say in the courtroom can and will be used against you. So when the attorney asks or the judge asks, HunnitK, did you ever sign a contract with Discover Bank? Most people say yes. Some people say no. I don't say anything unless they have facts into the record to prove it. Period, point blank. Because if I say, yes, I signed an agreement, that takes the burden off of Discover Bank to provide one, right? If I'm arguing that there's not a contract, and if the judge asks, well, HunnitK, did you sign a contract with Discover Bank? And I say yes, that relieves Discover Bank of their burden. Would y'all agree or disagree? All right, I'm glad y'all rocking with me. All right. So now, if the attorney does not have a contract, he has to be able to prove one. So what he's going to do is he's going to do interrogatories. So there's different versions. You can do interrogatories or you can do admissions. Admissions is more true or false questions. But here he wants to go more in depth. So remember, you're in the courtroom, the stenographer's there documenting everything. So you got to be mindful about what you say in court. So the first question that the counsel is shooting off is, please describe how you requested this account from the plaintiff, whether it was by mail, phone, online, or other means. Answer. They want you to answer this question because he can't verify it. He wants you to do it. Discover Bank can't talk. Discover Bank can't speak. Discover Bank can't sign. Discover Bank can't walk inside the courtroom. That's why they need you to testify against yourself. Now, we said earlier, right? For Discover Bank to be able to win, they have to provide a contract or an agreement into the record that establishes that. So why on number 4 are they asking us this question? Did you sign? We're going to look at it. Did you sign an agreement with the plaintiff for the use of the credit card? Yes or no? Yes or no, chat? Y'all don't find that funny? If you don't find this page funny, something is wrong. The attorney for Discover Bank is trying to win this case for $8,292.98. Did you sign an agreement with the plaintiff for the use of the credit card? Yes or no? This information he should already know. Why is the attorney filing a petition for breach of contract when he's asking me if I signed the contract? That should make y'all giggle. That should give y'all some more confidence because it's showing you this is how they move in court. It's not that bad as how people make it seem. It's not as bad as some people make it seem.